like to start the session with a topic that has been the central most topic throughout the day today, which is artificial intelligence. A lot of questions were posed on artificial intelligence to former Chief Justice of India, VIT Chennai. We have had extensive panel discussions on it as well. Mr. Raman, if I could begin with you, how do you think law school should prepare students to adapt to the advent of artificial intelligence and machine learning?
I think it's a bit of a trick question because in my personal opinion, the word artificial intelligence has been created to give a kind of a sheen insofar as using it in and for educative purposes. It's artificial. It's not intelligence. Well, you've been hearing today from the former Chief Justice of India, very esteemed senior advocate of standing in the Supreme Court, and a lot of people, I'm sure, would have told you that the days when when I was in college, well, there was not, the standard of education was not too high. Now, that posed a few challenges, which I believe have probably shaped the way in which I would address an issue of which I do not know much about. I have steadfastly refused to use AI, whether it's on my WhatsApp or it's whatever. However, I did use a software called Dragon Naturally Speaking. I was probably the first one in Madras to use it as a lawyer, something like about 20, 25 years back. Now, that's different. That eases the way in which you work. But this is a very dangerous tool insofar as students are concerned. I would not, for the life of me, begin to think that faculty would devote any amount of time teaching students how to use AI to learn law. Law is a very serious subject. You can't leave it to machine learning to tell you what the law is or what precedent is or which is the section which provides for the question that you have asked in a particular enactment. Now, I'll give you a very simple example. Well, I do remember from somewhere that in a document which is a testament, in testamentary jurisdiction, let's say it's a will, disposition of property, when followed by a para which says, look, this disposition is conditional, will mean that the disposition has already happened. Anything to lessen from that position is not going to hold water. Whereas in a contract, whatever is said at the end would actually make for the position which holds good in a court of law. Now, this is a very simple thing. There is a distinction. I know this distinction. Now, I don't know or I don't remember where I could have acquired this knowledge. Now, if I turn to AI and feed in these parameters, I'm pretty sure it will come up with some case law, it will come up with so many things. That is good for me because I'm practicing law. Now, I won't trust it. I'll obviously go back and check. But the fact of the matter is, education cannot be based on that. I would urge all students to go about it the hard way. Take your books. Learn. Because the bigger challenge than being presented with matter to read is to find out where to acquire that matter. It could be under the Transfer of Property Act, it could be under the Contract Act, it could be the Evidence Act. Take all three. Point is that unless you inculcate a desire to satisfy that thirst for knowledge by actually doing something yourself, you're not going to retain that knowledge. Therefore, I am completely against using AI as a tool for educative purposes.
Thank you, Mr. Raman. Professor, I'd actually like to come to you. You have a background in academia. Are you as pessimistic about artificial intelligence as Mr. Raman? And do you think AI tools can help with legal research?
Madam, good question. Artificial intelligence is one of the criteria where the student can collect some information. But the intelligence should not act artificially. Why? Because the intelligence will not come in a overnight. It needs hard work. It needs commitment. It needs sincerity. It needs dedication. Take an example. The law school in India, which started in the year of 1855, we have around 170 years of history. In that history, we have created many jurists. And those jurists, they always think brain as a technology, as a tool. Even in the courtroom itself, they have collected a lot of information and reacted. What the artificial intelligence will do, it is only the giving an information quickly. If you give the summarize the issue, automatically they will tell how they have to draft it, what all the relevant sections are there. And now you can use it as one of the criteria in the classroom, but that is not a only criteria. I will tell you one thing. If you are going to tell the student that you have to use the artificial intelligence, the student will depend upon the AI only. They are not depend upon their brain. Why? Because they tuning the brain, collecting the memory, remembering the section, it is not a easy things actually. I will tell you one thing. I think everyone knew about it in my classes also. I used to tell all my students to come up with the bare act and also with the book. In addition to the technology which they may use it. Why? Because if you have a bare act, then you can act quickly whenever the faculty handle the class. And you can use the artificial intelligence, but it should not be for 100%. I will tell you one example. For an example, first of all, the student should learn what are the existing legislation. Students should learn what are the existing information first of all. The learning process should not be dependent upon the mobile phone. I will tell you one thing. We have around 25 national law universities and also 1,200 law colleges and also the private institution. There is a survey that most of the students, they are depending upon the mobile phone. That is called as a mobile phone learning. And even they use the chat GPT. Nobody is against the chat GPT. But the only thing is that even in the chat GPT, even in the artificial intelligence, our senior advocate rightly pointed out that we should know when we have to use the technology, when we have to use our own intelligence, either to accept the technology or to defeat the technology. It will be applicable for everything. I will tell you one thing. Take an example. Recently also, we have a new criminal laws. For example, even in BNS 358, even if you go for BNSS 538 like that, if it is like around 700 section, if you tell the student that you go with the help of the artificial intelligence, no student will remember and recollect the section. No student will effectively argue the case before the court of law. For an example, I will tell you, even using the artificial intelligence also depends upon the which subject you are handling, which domain you are. For an example, if I am from information technology student, because I devote my studies in the information technology. Your profession itself is a legal profession. If you want to be a noble in the legal, but you should not depend upon only the technology. And one more thing I will tell you. Nowadays, what the process is happening, because normally everyone they are asking that whether as far as the future of legal education is concerned, the future is depending upon the only the technology or not. Why? Because many of them they are speaking that the technology is the major criteria for betterment of legal education. But my view is that that is not. But that is one of the criteria, but that is not a only criteria.
Thank you, sir. Mr. Krishnan, what are your views on this? Do you think concerns regarding originality in academic work can arise especially?
Yeah, I think AI can supplement legal research, but it is very dangerous if AI is the primary source of legal research. Now, if students use AI, AI provides a direct solution. It provides a direct answer to a question. What does this prevent? It prevents reading of commentaries. It comes in the way of reading case laws. Now, reading commentaries and case laws is essential for any student for many reasons. First, you need to understand the march of the law. Now, for you to understand the legal principle, it's very important to trace case law from the first case law on the point till the last case law. You will find loopholes in between. And it's very important to understand basic concepts. Therefore, the march of the law is very important. Second, when you read a case law, you may be searching for a case law on a particular proposition. If you go by AI might directly say this is the proposition, this is the case law. But when you search for case laws on that proposition, you are reading multiple case laws which discuss many other propositions. As a student and as a young lawyer, it is important to build your database of propositions and case laws because you don't know when it will come handy. Tomorrow you're dealing with a case, you will know that you've read this proposition somewhere, you'll broadly know where it is and then you can go and search for it. But if you're not aware of the proposition at all, you're going to be lost. Therefore, building that database of propositions and case laws is critical, and not reading case laws, not reading commentaries will come in the way of that, secondly. Third, if you need to have the skill of distinguishing a case law, you must know how to read a case law. If AI gives you the direct solution and you have not read enough case laws, you develop the skill by reading thousands of case laws during your law school and your early stages as a lawyer. If you have skipped this stage, it's a very important stage of development. Therefore, I am of the view that AI certainly can supplement. So, if I am a student, what would I do? I would still stick to reading the commentary first, writing down from the commentary the various case laws on that proposition, pulling out those case laws, reading case laws cited in those case laws, and then use technology to supplement this. I will search for case laws that follow these case laws. I will also then do an AI search to find out any additional material on all of this. But if you directly go to the last stage without the commentary and the next stage of reading case laws, that's an important stage of development. And lastly, when you read case laws, you look at innovative arguments that have been made. Now today, as a lawyer, when you need to put forward a new argument where there is no decided case law, you need to have seen similar arguments being made in the past. Let me give you an example. The famous basic structure argument of the renowned jurist Mr. Nani Palkiwala. You will find an argument that is about 70 or 75% similar made by Mr. M.K. Nambiar in Golaknath. Now, today this is how law develops. You read the earlier case law, you see something there, and then you innovate on what is already there. Now that AI will come in the way of all of that. Therefore, please use AI as a supplementary tool, not as a primary tool.
Thank you, sir. Professor, I'd like to come to you. What do you think is the future of legal education in terms of making sure there's confluence of other subjects as well? Do you think an interdisciplinary approach is the future?
It's a good question, ma'am. Actually, nowadays, even the University Grant Commission, and also even if you are in engineering field, All India Commission for Technical Education, Council for Technical Education, they are concentrating more on interdisciplinary and also multidisciplinary. That is what normally the people used to do. Take an example, I am basically from legal background. But if I have a science background, I can excel in intellectual property rights. And if I am having a legal background, if I have 1 or 2 degrees, because many of them they are coming from after engineering also they are coming, BTech then LLB, they can excel in the various field. And nowadays, it is not like only the conventional system we have, like a traditional system. Once upon a time, even in Tamil Nadu, this is the situation. Whatever the subject you read, it is maybe in international law, constitutional law, criminal law, property law, and contract law. There are 4 or 5 subjects. After 2012, even in Tamil Nadu, but there are around 14 subjects. Take an example, air and space. Take an example, law, science and technology. Take an example, space law. Take an example, cyber law. Nowadays, speak about law and sports. Like that, there are multidisciplinary. Now, the question is, how you will use the multidisciplinary. It depends upon how you frame the syllabus, first of all. Take an example, the person who is always interested with the framing the syllabus should know that how they have to frame the syllabus. I will tell you one thing. There are institutions in which the syllabus will be framed by the particular person. Now the question is whether the particular syllabus is really standard or not. Normally there is a probes. A good teacher will never ever complete the syllabus. Why? Because completing the syllabus, it should not be too much. Because I should not concentrate more on history. Otherwise, I cannot create a history. Rather, I have to concentrate more on theoretical aspect on the one side, practical aspect on the other side, how the student should apply their mind in the name of clinical legal education. Take an example I will tell you. As far as the future of legal education is concerned, the people are always talking about theoretical thing. But that is not a case. For an example, there was a survey, I will tell you ma'am, while I was handling the criminal law subject, 90% of the students didn't see the police station, didn't go to the police station. Didn't go, 50% didn't go to the, I'm telling about all of us, didn't go to the court. Didn't know the court that how the process is all about. But telling them to study only the books, it's a waste of time. We have to permit the student to go out and see what the real world is all about. Because without telling them the real, what is the real, for an example, if I am an academician, I should not give 10 to 20 assignment or 5 assignment by saying that, you complete this assignment and submit it, for this there is a mark. Even if it is a one assignment, you tell the student, go there, even take 4 months or 3 months, do the research. It is not like a theoretical research I am talking about it. I am talking about the research like an empirical. It's not like one person should do. Even 2 students, 3 students, 4 students should join together and see that which field in which they are interested. Normally the people can say, even the morning which I am telling about it, they are saying that we have to identify, we have to track that where we have to get an opportunity, where we have to get an employment, where we have to get a job. If you want to be a successful lawyer in your field, at least you should know 10 to 20 subject minimum. For an example, if I am an IP lawyer, I can talk about copyright, I can talk about the infringement of copyright, I can tell that section 63 and 51 is an offense infringement. At the same time, I should know the criminal law also, that under which law, under which section, and I have a power to take a cognizance as a judge. If I am purely on IP perspective, I should know theoretical perspective and also practical perspective. And one more thing, ma'am, as you rightly pointed out, and the future of legal education, it is not job oriented first of all. Because the people used to choose their legal field, it is only for social oriented, society oriented. And many of them, even because it's a universal fact, whoever comes to the law school, any law school, wherever you go, they ask the first question, is there any placement? Is there any placement? The point here, they're forgetting themselves that if they work hard, it is up to them, nobody will compel them. They go for practice, like a litigant lawyer. 10-year concentrate in a case study perspective rather than the theoretical perspective, they can get more than what one employee is going to give to them. And one more thing, there is always an issue by saying that 70 subject, 80 subject. Whenever there is a competition between 2 universities, one university will see the syllabus of another university and adding 4 or 5 subjects by saying that this is the new. Actually, that is not at all new. You take any law, foundation will be old. I will tell you one thing. And if you want to strengthen the legal education, first of all, students should understand something in the regional language. Take an example. Our senior advocate is here. He is doing a lot of things in Tamil, and he is also having a magazine in Tamil. Why? Because the people who understand whatever the case comes in Tamil, but he should be always efficient in English and their respective regional language. The true and also the exact information of the particular case, we can cherish it. But that is not happening, I will tell you. And the student is, not all the student I am telling about it. Percentage may be less. The student always thinking about it, how the future of legal education, how we have to settle. Rather, the student should think that how they have to equip themselves, because it cannot happen one day. You ask with any senior lawyer, I think our senior advocates knew, even in the practice, you will never ever excel in a day. It will take 10 years, it will take 15 years, and it will take 20 years also. Even in the legal field, after 25 years only we will know, even if we don't want money, the people will come and approach. Why? Because if you search the knowledge, money doesn't issue. And then money will search you by saying that where you are. But as per the future is concerned, when we are discussing a future of legal education, that itself is very pathetic. Why? Because there is no end to the legal education, ma'am. Thank you.
Thank you. So some very valid points made, especially because, I mean, right after graduating, if you were to go into litigation, you won't get the luxury of specializing. That much comes much later. So to have that grasp on all legal areas is very, very important. Mr. Raman, I would like to come to you. Do you think that law school should focus on making sure that law students are taught more by practitioners?
See, to give a flavor of what is actual practice, I genuinely believe that law practitioners would probably be in a better position to impart certain skill sets. It need not be purely theoretical. It could be in the realm of ethics. I'll tell you very frankly, see, this is an occupation which pays. Now, as students, you should also be curious. Now, tomorrow if a client comes and says, listen, I have a problem and I'd like you to handle this for me, you are expected to charge a fee. The conduct rules of the Bar Council of India says, please charge a fee. Point is, how do you go about it? Now, these are all very simple things which might come naturally. But it's always good to have some knowledge about how this goes about. Another area where I would believe that experienced legal professionals could help is, of course, areas where, particularly in litigation practice, how do you conduct yourself? How are you expected to address court? How are you expected to prepare, for example, let's say a conference where you're briefing a senior counsel, an arguing counsel. What are you supposed to do? Now, I do not know whether your current curriculum would cover areas like that, because one of the key takeaways would be, when you go into a conference, the person who you are going to engage is probably a little more or far more experienced than you. Decisions would be taken at that stage to pursue a course of action or not to pursue a particular course of action. This case for which you are going there could be at some interim stage. Now, if you have not made a note in that conference as to why that decision was taken, this particular matter will come up for final hearing with you having 10 years under the belt. You would not even remember why I did it. These are all certain nuances which ultimately provide for a professional way of going about your work, a systematic and efficient way in which you can safeguard yourselves. One of the first things that I was taught, at least, is your worst enemy in your profession is not the lawyer opposing you or the client of that lawyer who's opposing you. It is your own client. It's important because, see, experienced practitioners, we know there will be one question that is asked which will stump you. And the client would probably feel that, things are going out of hand and why did this happen? I'm sure there are so many naysayers who are going to advise these people, look, this is what went wrong in your case. These are all little things in which probably legal practitioners would be able to impart a sense of confidence in you when you actually go out into the open. So I am not advocating for a moment that legal practitioners should be engaged as regular, or rather be given the work of regular faculty, because regular faculty is structured. They know where to start, where to stop. Legal practitioners never know where to stop. They only know where to start. So to answer your question, yes.
So actually on that note, so under the BCI rules, full-time faculty members are not allowed to practice. Do you think a reform is required? Especially because the NLU consortium back in 2019 had actually passed a resolution to this effect.
No, I feel that regular faculty being allowed to practice is a very positive thing. The reverse may not necessarily be true, which is why I said legal practitioners should not be given the actual work that faculty do, the actual curriculum which a faculty member is expected to impart over the course of a particular term, because he will mess it up. He's got other things to do. But the reverse, yes, I fully support it. They must be allowed to practice.
Thank you, sir. Mr. Krishnan, coming to you, I think one of the most common criticism that we see is that law schools focus on rote learning. Do you think the curriculum, the questions, they should be more application driven? What are your experiences?
See, I think a mix is important. I am not a person who believes that there should be no rote learning at all, because there are two things that a lawyer needs to know. First, what is the law, which is most important. And for that, you can't be in the air all the time. You will need to know, well, if you are dealing with a specific relief act, you will need to know what is the provision dealing with readiness and willingness, for instance. So knowing what the law is paramount, and that comes first at the undergraduate stage, where a certain amount of rote learning is inevitable. But when you go from the undergraduate stage to the postgraduate stage, that is where it needs to become entirely application based. For instance, when you look at courses abroad in Oxford, Cambridge, etc., you will have very few lectures at the postgraduate stage, and you will have more tutorials and group discussions, where for a group discussion they will give you a proposition, they will give you reading materials. You read all those case laws, all those articles, and you come, and then there is a debate based on that. Now, at that level, they don't go into what the law is. They go into why the law is that way. Or how do you interpret the same case in two different ways. Now, these are also important, but you will not be able to get to this stage without knowing what the law is, for which rote learning is important. Therefore, it's possible to say that maybe at the postgraduate stage, we can shift more to an entirely application-based approach, but I think that finding that mix is very important. Otherwise, it will become like the proverbial four blind men describing an elephant based on which part they touch without knowing what exactly there is.
Thank you, sir. I would also like to talk a little about litigation as a career prospect, especially because we have so many law students here in the room. We don't see law students pursue or want to pursue traditional litigation anymore. How can we incentivize them to do so?
See, what happens is that there is when Professor was talking about placements. Now, when you go for placements, you have the corporate law firms that offer possibly 3-4 times what the litigation firms and the traditional litigation offices will offer. And in a corporate law firm, for every 10 corporate law transactional job, you will have one litigation post that comes up. Now, initially, that lure is there. In a lot of cases, there is genuine financial need. I'm not belittling that. But the difficulty is once you're in that system, even if you want to litigate, it's difficult. You need to come out at the right time. If you stay there 7-8 years and then want to come out, you spend too much time in that system, too much time developing another level of specialization, and then it's difficult to come back and become more of a generalist or to step into a litigation, because you develop a lot of skills in the first few years as a litigator, which you cannot miss out on. So I think what is required is for students, well, you want to go make your money, do it for the first 2-3 years, build your bank balance, and once you are financially secure, come back, but come back within, say, 3 years. It also requires a lot of mentorship, because for students without any background, without any family in law, may feel that making it is difficult. There is a long wait period before you really make it as a litigation lawyer, and during that wait period you will earn significantly less than your friends and peers in corporate law firms. But once you get past that wait period, I don't think there is any comparison. As Mr. Raman was mentioning, it's an occupation that pays. So I think that mentorship and that assurance to young lawyers that wait it out few more years and you can really make it is something that is important.
Thank you, Mr. Raman. I would actually like to come to you. From your experience, how can we encourage young law students to pursue litigation, and also more importantly, how can bar associations or even the judiciary help to make sure that for young lawyers, litigation is a viable profession?
See, I think most law students would probably have attended some amount of counseling before they joined law school. Now, you might have had some preconceived ideas about what you want to do as a lawyer, whether you want to do corporate practice or whether it's a stepping stone for you to study more and then get into some other field, or perhaps you were always born with that gut feeling that I want to litigate. It is not a choice which others can guide you to do, but definitely provide a platform for, yes. The platform begins, for example, now I have a grievance. Courts are not allowing students that easily to come in. You have a problem, you have security measures in place. You can go to the lower courts, yes, but not to the high courts or the Supreme Court. You have to go in batches. You can't go as you wish. I'm sure you have probably enough a faculty to take you there and then make the pass and do all that, but it is a process. Us, in our time, for example, the High Court here in Madras was walking distance from our college. At any point of time, something we read in the papers, something very interesting, some constitutional point, something to do with the elections, assembly, etc., we would just walk into the court. We would see stalwarts battling it out. It left a huge impression on us. On the days when you were taken to court, you might probably, I wish you well, but these kind of battles don't take place every day. Every day, if you go and see something, you might not even understand what's going on. This is where I find that there could be a help, a push, to see that access is easy. I was talking to my junior colleagues in the office as to whether students are allowed in the online viewing. I was told it's not very easy. They will have to disclose, they have to get permission from the registrar, etc., which is also cumbersome. So how will you have a taste of what it really means to stand up in court and argue your client's cause? That thrill, I can tell you, your corporate practice cannot match. Legal practice, what it pays, in terms of the first phase till liftoff, you cannot match corporate practice. But there is a balance, as Anirudh points out. Now, where probably the BCI has been doing good work, I'm not saying no. They have been conducting learning courses, they've been doing a lot of things. But what I find is the BCI itself seems to be in a bit of a quandary. I was just coming across a notification issued by the Bar Council of India last year, complaining about the mushrooming of law colleges. The problem is that when you want to start a law college, you go to the the Education Ministry of the state concerned. So the Higher Education Ministry first, let's say, gives you permission. Then you go to the university, get your affiliation. And only after that, the Bar Council of India comes in. By that time, infrastructure is built, investments are made. So what does the BCI have to do at that point of time? They can only come inspect and, probably give you some a heads up on what is wrong, what needs to be done. I think there is a need. I think perhaps you're going to touch that topic again, but point is, I think there is a need for a unified body. This consultative process between the UGC and the BCI, I think, will work better if it's a unified body and lots of heads are put together before an institution is started. After an institution is started, it is practically impossible to shut it down. Even with violations, even with so many misgivings on how much staff is employed, whether students are coming or not, what is it that the BCI can do? So these are all issues pertaining to powers of the BCI, and it's a statutory body, so something has to be done. This is what I feel. But the point is to incentivize students to become litigators. The question also arises, don't we also need corporate lawyers? Of course we do. So it's a Hobson's choice. So you need to make up your minds, and to make up your minds, all of this exposure is brilliant. Come to court, see all this happening. Or if you want, you can go to a corporate law office and see. It might be a bit boring compared to what happens in court. But there is a thrill in that. If that's what suits you, good. So point is, today I am told that students are having apprehensions about getting into practice for a variety of reasons. It is physically taxing. It is probably something which you would not have imagined that you're going to be put through with the coat and the gown and the summers and all the heat and everything, running around carrying books. But there is light at the end of the tunnel. I can promise you that. I can promise you that. And to incentivize you to do that, the first thing that has to be done is access to court halls must be made free for students. It's very important.
Thank you. So I would actually wanted to talk a little more about the limitations of the BCI and whether we require a separate regulator. But we're out of time. I'll just hand it over to Professor. Sir, if you could just also tell us if exposure to legal aid could maybe help students develop an interest for litigation, exposure to practical realities.
Yes, ma'am. As far as the legal education is concerned, let us take our university, VIT School of Law. Periodically, we used to do the legal aid. We used to tell the student to go to the nearby places, to mingle with the student, and also mingle with the community, and also the downtrodden people, and also the needy people. And there are issues. For an example, if you go to one village, there are 1,000 issues comes. Take an example, sir, we are living in the particular area, we don't have any pata. Many senior citizens, they are saying that our kids are not taking care of us. And also they are telling many benefit, the government benefit, it's not coming. Few of them are telling, sir, the crimes against human cases and all, sir, High Court it is pending for 10 years. Sometimes the district court it is, like more than that. We don't have any awareness. What we do it from our schools, and we used to invite the judges, we used to invite a practicing advocate, we used to invite an academician, and those who are in the field, tell them practically with the help of the district legal authority that how they have to solve the issues. Even many students, they are coming forward and they are doing it. I will tell you one thing, ma'am. Even as a teacher, I cannot advise as I like. For an example, I am handling around 4 subjects. What I will do, if I want to tell the student, there is a process called Monday petition. In Tamil, they used to tell Kurai Dirkum Nan. I will go as a common citizen and look into that, what is the step-by-step process. Even if you go to the collector office, how we have to file the application, in which place it will go, when the petition to whom, when it will go to the DRO, when it will go to the Tahsildar, when it will go to the Deputy Tahsildar, then when it will go to the Revenue Inspector, RI, then finally where it will go to Village Administrative Officer. Like that, there is a step-by-step process. Legal aid, it is a real instrument where we can help the needy. That is what we are doing it from law school also, ma'am. And also it is an opportunity to student to learn practically how we have to face the client. how we have to face the society. That is because even in our law school, we have started in the year of 2014. The first legal aid in the year of 2014, we had it, and 2014 and 15 in a place called nearby Sengalpattu, because we went to the Tirupur and other places. There are a lot of issues. Not only in one legislation, around 10 to 20 legislation, we can learn it in one legal aid. Only one legal aid. Nowadays, there are so many complaints, particularly for an example, the senior citizen complaint. And one more complaint comes because as per the city is concerned, there are two issues. One is rent control issues. Another one is they are residing in the particular place, they don't have any pata. Our student used to tell the simple advice by saying that if you don't have any land, you can apply to the government so that they will give 30 cents. Likewise, practically, it is not easy also to give the advice. We have to update ourselves. We have to seek the help of our legal aid team. And also, the student also used to prepare well in advance. Periodically, we used to prepare the report also. And also, we will know and well in advance and go to the particular villages also. And also, ground reality will do that what are the issues which they are facing it.
Thank you, sir.
Thank you.
We'll open the floor for questions now. Any questions?
Good evening. Good evening, panel. My name is Avantika. I wanted to know why there is this gap in our legal syllabus. For instances, in subjects like jurisprudence or Indian legal system, we have concepts like dharma. And whenever we talk of philosophers, we talk of people like Manu or Kautilya. We never talk about people like Thiruvalluvar or even the post-colonial pioneers of movements like the self-respect movement. And when we are talking about incorporating AI into our legal system, possibly so, wouldn't we essentially increase the cultural bias that is already in place without rectifying the very little issues such as this in our already existing system?
Mr. Raman, would you like to respond?
Well, actually, let's say about 100 years back, legal education included Roman philosophy. So Roman law was studied. I didn't study Roman law. Yes, writings of Manu, old Hindu law, all of that was taught to us because there was a significance in terms of how courts interpret that law. So when there is, let's say, a vacuum, they try to go back and see what was the previous position of law. What you're speaking of is that, for example, Thiruvalluvar's work, it was probably taken into consideration in systems of law and courts very, very many years ago. So the significance of studying that, I do not know whether it is of use to a person who is learning law. So the other question is AI. You are absolutely right. AI is going to increase the bias, and our earlier systems, the oldest systems of law and reliance on learnings of our ancestors is going to get lost. I agree with you on that, which is the reason why I do not want you to go to AI at all. Thank you.
Yes, please.
If I can add to that, when you look at jurisprudence, you look at principles which explain propositions of law. Jurisprudence helps you understand the why behind the law. And it is those principles and those philosophers that you usually study. I'm not an expert in framing the curriculum. Like for instance, Austin, law is the command of the sovereign. Directly relatable to you construe a tax legislation strictly because it's the command of the sovereign. You look at sociological school. Law is social engineering. Right? The directly relatable principle, when you construe a welfare legislation, you look at the object and you beneficially construe it. So there are various theories of jurisprudence are directly linked to various propositions of law, and usually it is those philosophers who you study whose theories have been used to develop legal principles. Another great example is the theory of Grund norm, and whether the basic structure of the constitution itself is the Grund norm from which everything else emerges. So there I think jurisprudence really helps, and the focus while framing a curriculum is perhaps on those philosophers whose theories have helped develop legal principles of this nature.
Do we have any more questions? Yes, please.
Good evening, sirs. Considering the fact that legal education is not just a mere privilege for the law students, when it comes for whole India, all the citizens of India are supposed to learn has to have legal aid or legal education. And how do we promote legal education to the whole citizens of India? And my second question is that if we promote legal education in India, how will it affect the future Indians, and how will it improve the jurists in the future?
Yes,
I
please.
think probably this is a question you'll have to address Fort St. George. Point is, we can only practice law. You want to educate across the country persons who are probably not that educated themselves as to their rights. Yes. If you want to teach them law, the problem is a little knowledge is very dangerous. So, how to propagate knowledge which is going to be useful to the common man so that he can understand his rights, his basic rights, his fundamental rights, is something which, government policy should be looking at. I don't see a role for a lawyer in that sphere for the simple reason that as a body, maybe yes, maybe as a body, the Bar Council of India or perhaps a whole university or a group of universities can carry out such programs. But there are so many other good things to do. People know their rights. We are a very litigative country. There is enough litigation.
Thank you. We have time for one more question. Yes, please.
Good evening to the distinguished guests. My question is, in this age of technology and artificial intelligence and other things, and increasing interest in the corporate field by various law students, is there a diminishing trend for the inclusion of social sciences in the study of law? Because without knowing the social background, one will not be able to understand the ground reality, and without understanding the ground reality, application of law will not be possible in a very effective and imperative manner. So is there a diminishing trend for the study of social sciences included with law?
As far as law is concerned, it is inclusivity and also accessibility. No one can compel any student that you have to study this subject. It is free for them. They can choose any subject. That is the reason why in the law universities and all the private universities, they have a different subjects. For an example, in our VIT School of Law, we have an elective subjects. Whoever wants to choose the particular subject, they can choose. That is called as a fully flexible credit system to give the flexibility to the student to choose it. Nothing wrong. For an example, more than 90% it is not about corporate cases. But if the student want to pursue the corporate law, that is their freedom. But what we have to do, normally we used to identify, invite the people who is in expert in the particular field to come to the law colleges and to deliver a lecture. Take an example, teacher cannot be a master of all the subject. The teacher can be a master only in a few subjects. For an example, whoever is practicing in a court, because they are a real master, they know what all the issues are there. We used to invite them and we used to request them to deliver a lecture. That is what we are doing it. And it's, as far as the corporate field is concerned, just because something is a blooming, it doesn't mean that other subject and other area also will be diminished. It will never ever be diminished. Thank you.
That brings us to the end of the session. Thank you so much, dear panelists, for your time.